Good morning, good afternoon, and good evening, everyone, depending on where you are connecting from. And a warm welcome to this panel on the evolving role of arbitral institutions. My name is Dr. Remy Gerbet, and I have the pleasure of chairing this panel today. And for those of you who have not had a chance of meeting yet, I'm an academic at Queen Mary University of London and a partner at a litigation boutique firm in Washington, D.C. called Molo Lemken LLP. And in a previous life, I was a deputy registrar of the LCIA and the registrar of the IFC-LCIA. Now, the topic of arbitral institutions and their many and evolving roles is one that's very close to my heart, but the true experts are the four great panelists that we have for you today in Barbara Varvas, Qian Bao, Ismail Selim, and Alexi Moore, who I look forward to introducing to you in just a minute. Now, before I do that, just a couple of words about how we're going to structure this panel. As you know, this panel is going to last 60 minutes, and we will follow a roundtable format, which means essentially that I will be taking our four great panelists through a series of questions, all relating to the role of arbitral institutions. Questions, some of which I think are quite controversial and hopefully will yield some thought-provoking discussions for us. Now, obviously, none of the speakers today are speaking on behalf of the arbitral institutions with which they are or have been associated in the past, and instead they are expressing their own personal views. Now, the roundtable segment of the panel is going to last about 45 minutes. And when we're done with that, we'll have about 15 minutes reserved for questions from the audience. We very much look forward to hearing from you during that Q&A session. And so for these purposes, please do feel free to submit your questions to the panelists using the Q&A function that you should see on your screen. Another thing, when this panel ends in about 60 minutes, you will have an opportunity, if you so desire, to join a separate Zoom meeting called a Continue the Conversation meeting, a CTC Zoom meeting, for which you should see a link at the bottom of your screens as well. The purpose of that CTC Zoom meeting is for you and us to continue to the discussion and have an opportunity to take on further questions beyond the time allocated for this particular panel. So we look forward to seeing you there as well. Now, as I was saying just a minute ago, we're very lucky to have four great panelists today. And my short summary of their biographies is simply not going to do justice to their many accomplishments, but I will try my best. Starting with our first panelist, Barbara Varvas. Barbara is an academic based at the Hague University of Applied Sciences in the Netherlands, where she has taught, among other things, dispute resolution, arbitration, and comparative law. She is an authority on the topic of this panel, the topic of arbitral institutions, having authored one of the leading treatises on the subject, a book called The Liability of Arbitral Institutions, Legitimacy Challenges and Functional Responses, which was published by Springer in 2016. Prior to joining the Hague University of Applied Sciences, Barbara worked as a visiting counsel in the litigation department of GE Oil and Gas in France, Italy, and she was also working in the Italian law firm Studio Legale Calabresi Guadalupe. Our second panelist, Qian Bao, has over 20 years of experience in the field of international arbitration. She now practices exclusively as an arbitrator and a mediator. She may very well be known to you as the former Secretary General of the Hong Kong International Arbitration Center, a role which she occupied between 2010 and 2016, a period during which the Hong Kong International Arbitration Center continued to grow and really continued to establish itself as one of the leading arbitral institutions worldwide. Now, prior to and after a role at HKIAC, Chan also practiced international arbitration in various law firms in New York, Hong Kong, and Paris. Chan is connecting from Singapore today, where it's about midnight. So we're very thankful to you, Chan. Chan, last thing, currently serves as a vice president of the ICC Court of Arbitration, I think, and she's the chair of the ICC Commission Task Force on Arbitration and ADR. She's also a member of the ICC's Belt and Road Initiative Commission. Third panelist is Dr. Ismail Selim. Ismail is the director of the Cairo Regional Center for International Commercial Arbitration, CERSICA. Dr. Selim, or Ismail, started off his career as a prosecutor in the office of the Prosecutor General of Egypt, and then he became a civil judge in the country. He then also practiced international arbitration at two law firms, first at Zulfikar and Partner, where he was a partner, and then at Noor and Selim in association with Al-Tamimi and Co., where he was the head of dispute resolution. Ismail has taught over the years at many academic institutions, including, for example, the Sorbonne in Cairo. And of particular relevance to this panel today, he is the Secretary Treasurer of IFCAI, which is the International Federation of Commercial Arbitration Institutions, a position which I'm sure gives him plenty of insights beyond, of course, CERSICA and Cairo. Last but not least, we have the pleasure of having Alexis Moore with us on the panel. Now, Alexis needs no introduction, but I will try to introduce him nonetheless. He is, of course, the immediate past president of the ICC International Court of Arbitration, having served before that as a vice president of the court and also as a vice president of the ICC Institute of World Business Law. He now practices exclusively, I think, as an independent arbitrator, if I'm not wrong, in Paris, having been, of course, at the heart of the international arbitration community in Paris and beyond for over 35 years now. Now, Alex's name is, of course, intimately connected to the ICC, but the ICC is by no means the only institution that he has had an opportunity of helping and supporting throughout his long and successful career. And for example, Alexis was a vice president of the LCIA court between 2012 and 2015, and was also a council member, I think, of the Milan International Chamber of Arbitration for almost a decade. So again, giving him plenty of insights well beyond the world of the ICC. So all of this to say that we're incredibly lucky to have such a great group of panelists to talk about the subject of this panel, which is the evolving role of arbitral institutions. And so without further ado, we're going to move into the roundtable segment of our panel. And I'm going to start and kick off immediately with a question that relates to the so-called normative or regulatory role of arbitral institutions. I think we all agree that the primary role or function of arbitral institutions is to administer proceedings, to provide administrative services to the institution's users in connection with arbitration proceedings. But some observers have argued that in recent years, arbitral institutions have started to take a different role, one that is more normative or a regulatory role. They point to the fact that in the new arbitration rules or in soft law instruments, arbitral institutions have recently started to regulate one way or another the use of tribunal secretaries, for example, the regulating counsel conduct, at least for the LCIA, regulating third-party funding. We know that it's an issue that is very much in debate in the current rules revision process at ICSID. And so some observers argue that institutions are no longer just private services providers, really providing their administrative services to the international arbitration community, but really policymakers. And so if we take, if you want, a sociological look at international arbitration, like Professor Emmanuel Gaillard and others have done, it seems as though arbitral institutions have become or are becoming the guardians of the collective values of the international arbitration community as a whole. So my first question, perhaps to Barbara, is this role really something that's new? Is that good? Does that raise issues of legitimacy? What's your take on this, Barbara?
Thank you very much, Remy. And I would like to start by thanking the organizers for the kind invitation and welcoming all viewers and my distinguished co-panelists. And I'm very honored to kick off this discussion, and I really look forward to our discussion. Coming back to the question, yes, I do think that arbitral institutions assume a regulatory role, and I think that they always did. The question is only what this role implies and vis-a-vis whom it's assumed. And I would like to answer this question by maybe sketching very briefly a historical evolution of institutional arbitration, so that we can have a broader understanding how the function changes. If we look at first sets of arbitral institutions when they were established, and I mean here big players, ICC, Court of Arbitration, LCIA, AAA, at the end of the 19th century, at the beginning of 20th century, we see that institutions always regulated the conduct of users and arbitrators. They did it slightly differently because the framework for arbitration was different. The parties wanted the system to be self-governed, and institutions also had a little bit more dynamics or a little bit more tools vis-a-vis users. So they were just trying to make sure that the awards are enforced, and the system existed outside the laws. So these reputational dynamics and social capital that needed to be maintained, that was at the core of the regulatory function of arbitral institutions. Of course, now we have a completely different world, and we have a completely different institutional arbitration system. We have a New York Convention, we have more legal demands on the process, we have more legal requirements for arbitrators and the parties, and we also have more and more public demand on arbitration. So, for example, in Europe, there is an increasing discussion on new roles for investment arbitration, investment court system, and so on and so forth. But also for consumers, we see the function of arbitration expanding. And so is the function of institutions, also regulatory function. That means that institutions now mostly are actually regulated the legal side of the proceedings, and they have to do this. At the same time, they also need to make sure that the system and the process is efficient, and that the users are happy with the costs of services and the length of the proceedings. So that's the main challenge and driving forces of regulatory function today: legality and efficiency of arbitration. And it also means that this regulatory function, at least as I see this, is exercised vis-a-vis new actors today, not only users. So we have, of course, parties that are interested in institutional arbitration proceedings, but then we have also judges, and arbitral institutions must ensure that the process is legal and that the awards are enforceable. We also have regulators, we have parliamentarians, policymakers who make new laws and sometimes even expand the arbitrability of disputes. And we have the public, we have citizens, we have the public that hears often quite negative opinions about arbitration. So I would say that in the past, and just to summarize, to give the floor to my co-panelists, the regulatory function was mostly concerned with internal legitimacy of the system. And now we also have this regulatory function tailored towards external legitimacy, to what extent other actors are happy with arbitration and how they see arbitral institutions. Thank you.
Thank you, Barbara. I don't know if Alexi or Ismail or Chan have specific follow-up points on this normative role of institution. If not, I was going to. If so, please do let me know. Otherwise, I was going to ask Chian a follow-up question. Go ahead, Alexis.
If I may, on this very briefly.
Please.
I think that you cannot dissociate the role of institution in their task of administering proceedings and their role of setting rules. It is intimately linked, and institutions do set rules in the context of their administrative function of case management, of course. Now, Barbara is right in saying that the function has mutated to a certain extent, in the sense that now institutions are perhaps more concerned about the global legitimacy of the system, and that has an effect on the way in which they set rules. And this is intimately linked to the evolution that we are seeing, in the sense that arbitration is becoming more complex, as we all know. At the same time, the pool of arbitrators expand, it's more diverse, and this creates a need for more guidance and for more regulation. So I think that this explains, to a certain extent, the tendency that we see.
And interestingly, I mean, these arbitral institutions, of course, don't just act through their secretariats, their permanent organs, but also they act through their diverse governing bodies, whether it's a court, a board of trustees, board of directors, and so on and so forth. And these governing organs are often, if not always, composed of individuals who are stakeholders, right? Who are private practitioners, arbitrators, in-house lawyers, maybe not enough in-house lawyers sometimes. But they are stakeholders, and so it's as if the arbitration community itself, I guess, through these organs that are more or less representative, I guess, self-regulate in a sense. I don't know if you agree with that.
Well, that opens an entirely different question, which is that of the governance of institutions, which is different, of course, from institution to institution. You mentioned boards. The ICC has a bureau of the court, which is composed by vice presidents. It has a governing body. It has a secretariat. The secretariat does not set rules itself. Rules are approved by the bureau of the court. And then, if we're talking about the rules of arbitration, they go to the ICC executive board. If we're talking about guidance, the practice note, it is approved by the bureau of the court. But each institution, of course, has different governance rules, and the extent to which these governance rules meet certain standards is, of course, a very important question.
Thank you. And so a follow-up question was, I mean, so far we've talked about arbitral institutions as if the notion, the concept was a monolithical one, as if there was such a thing as, one type of arbitral institutions. But perhaps, Chian, what's your take on that? Is that really fair to talk of arbitral institutions as a single, a notion?
Yes, thank you, Remy. I think that the default assumption from the external perspective is that arbitral institutions serve one purpose and have a common purpose. But in fact, arbitral institutions are not all created equal. Many of them are founded by governments. Many of them are founded by local chambers of commerce. Some are for-profit, some are non-for-profit. And so there are many different perspectives and motivations behind arbitral institutions. I do think that the by and large, the main goal as the modern day arbitration institution is that of the legitimacy of the system, and the functioning of their rules, or at least their responsibilities as has been bestowed upon them, or they have created in their own right to serve the purposes of the constituents that they intend to target, whether it be the local community or the international community at large. So in short, there is no common vision, I think, across all institutions. I think you can group institutions into categories, but by and large, I think it is very difficult to create stereotypes amongst institutions.
Yeah, and I think it's a really interesting point. I mean, in your part of the world, in Asia, I'm thinking not so much Hong Kong, but mainland China, of course, you've got a number of very large arbitral institutions, very active, which have been set up by statutes of the CTAC and others, so by statute of the government, their finances are also heavily reliant on the government. Some of these institutions can even be staffed by individuals that are functionaries of the state, and that's of course a very different situation from just HKIAC, but also the ICC, the LCIA, and others, which have been set up independently of the state, and so that's already a big difference. And another organization like the Cairo Regional Center have been set up as a result of a treaty, I guess. So I don't know if that has an impact as well on how the institutions operate and how they see their own role. Whether they see their role as being really something that's a private service provider role, or one that goes beyond that for the benefit of the broader arbitration community, and in fact the user base of these institutions. So I don't know, Ismail, if you have any view on that.
Well, yes, I agree with you. It depends on the institution, as mentioned, Xian. Institutions cannot function always the same way. There are certainly some common goals: efficiency, impartiality, independence, and the support of the arbitral proceedings in order to depart from ad hoc arbitration where there is no institution. So an institution must play a role. However, it differs from an institution to another. Some institutions, their rules are very much elaborated and others are less elaborated. It does not mean that the normative rule differs. For example, if we see the rules on joinder, the Swiss rules regulate joinder in a single article, which is Article 4.2. The Cairo Regional Center regulates joinder in a single paragraph, also like the Swiss rules, which is Article 17.6, which is identical to the Arbitral Article 17.5. And we see the Hong Kong Center, HKIAC, which regulates joinder in a very long article with many, many paragraphs. So they do it in different ways. I would say in the beginning, the institutions, if I go back to history, they were sort of the invisible hand. I would do the analogy with Adam Smith. And then with the development of international arbitration, the normative role expanded. If we take the example of the Corsica, and you have mentioned that we have been established by virtue of an international convention, the Corsica could not have succeeded in another way. It was the first institution of this ambition to be established on the African continent. We are back to 1979. At that time, arbitration was either administered by ICC mainly. It was the oldest institution and the prevailing one. There was much less competition with ICC when it comes to institutional arbitration at that time. And there was the other model of international arbitration, which was the uncitral ad hoc arbitration. So we chose to follow the uncitral rules and to be established as an international organization so that the foreign investors and the international parties would accept Corsica with a system of being immune from the host state.
That's interesting. So one point that you raised, Ismail, I don't want to distort your statements, but one point that you sort of hinted to at least was the fact that perhaps there is this perception that historically arbitral institutions were more like an invisible hand, you said, so perhaps less heavily involved in the actual proceedings that they administer. And so I think the idea is that the situation has changed and that the level of, or the depth of involvement of arbitral institution has increased over the years. Some talk of related but not identical concepts of judicialization, institutionalization of arbitration over the past few decades. And I guess it's true that if you look at the sets of rules of the ICC, the LCIA, or other institutions, every time they got revised, they became a little bit longer and longer. So you would be forgiven to believe that this increase in size of the institutional rules also reflects an increase in the level of involvement of the institution in the proceedings. Not sure that that's necessarily right, but do you agree here on this panel that institutions today are a lot more involved in the proceedings, a lot more hands-on in the proceedings than they were perhaps in the 80s? Is that something that's quite right, you think, or not?
Well, I would say this, Remy. I think that a distinction needs to be made between the regulation of the process and the arbitral discretion in the conduct of the procedure. Mm-hmm. And institutions, at least the ICC, has always been very attent to maintain and, in fact, to emit rules that allow arbitrators to exercise their discretion in the conduct of the arbitration. And many of the rules that have been emanated by the ICC, be it in the ICC arbitration rules or in the practice note and under my presidency and before, has been made with the objective of protecting the arbitrator in the exercise of their discretion. Now, it is true, nonetheless, that a certain number of rules have been emitted in order to create binding rules which have the effect, to a certain extent, of limiting the parties' freedom of choice. That is true. You can take the example of the expedited rules, where there is a provision saying that the court can disregard an arbitration agreement providing for 3 arbitrators and the point of sole arbitrator. You can take the new Article 12.9 of the rules, which deal with unconscionable arbitration agreements. We have introduced Article 13.6 in treaty-based cases concerning nationality. So it is true that all these rules, to a certain extent, limit the parties' freedom of choice. So you have these two things. You have more regulation of the process, and that at times comes to the expense of party autonomy. That is true. And you have, on the other hand, an overarching philosophy of institutions, in particular the ICC, I think, which is aimed at maintaining the arbitrator's powers and discretion in the conduct of proceedings.
And that balance is very interesting, because I always assumed, because of my past at the LCIA, I had always assumed that the users of the systems of arbitration really wanted an arbitration institution that had a so-called hands-off approach. It was the conventional assumption that people had at the LCIA, and I think at HKIAC as well, because I've seen that in HKIAC literature in the past. And a number of years ago, 7 years ago, we did an empirical survey at Queen Mary University where we sought the views of in-house counsel in 3 industry sectors. It was financial services, construction, and oil and gas. And we asked the users, so in-house counsel, if they had a preference. And the vast majority, something like 75% of in-house counsel, responded that they preferred an institution to have a hands-on approach and a very active role in the administration of the proceedings. So that came as a surprise. And I think it illustrates perhaps a disconnect between what the actual users want and appreciate and the concerns that outside counsel and sometimes arbitrators might possibly have. I don't know if you have any view on that.
No, I think what users want, and that there should not be a difference between users and their counsel. What users want is predictability. They want to know where they go, and they want to know, and the more the arbitration is complex, the more you have large multi-party, complex, multi-contract cases, the more users will want to know where they go and to be able to predict what the institution will do. And that's what rules are about, to provide certainty, predictability, and allow users to be assured that the process, the arbitration, will be maintained on the right track. That's what they want. And of course, we are in a context in which arbitrations are more and more complex, and that calls for more and more rules. Now, it is also true that parties and counsel want institutions to be hands-off, in the sense that once the tribunal is in place, everything that pertains to the conduct of the arbitration within the framework of the rules is for the arbitrators to decide. What I think users will not want is institutions impinging in what is the jurisdictional role of arbitral tribunals. So you have these two things again.
Barbara, I see you have a comment.
Yes, I just wanted to add that, of course, there is a paradox. I agree that users also complain about the institutionalization and judicialization, but it is what it is because users are more sophisticated and disputes are more sophisticated. But I also would see an opportunity in this process of institutionalization. Take, for example, the recent pandemic. And institutions, because there are so many rules, policies, channels, cooperative channels, also cross institutions or cross institutions, institutions can also take it as an opportunity, and they do. And I think they pass the test in the pandemic when it comes to the use of new technology and online hearings and discussions in this regard. So I think that it can also, as long as institutions are willing to innovate and are responsive to constructive criticism and demands and the current events, I think it can be also a positive development.
So if we have no further comments on this, I'm going to come back to a point that Alexei was raising just a minute ago. He was saying what users don't want is for an arbitral institution to cross the line and really start to encroach on the, I guess, decision-making power or function of arbitrators. And I think it's fair enough, but I wanted to explore this because it's a topic I love. It's also very controversial, and so I hope I can get your views on this. But generally speaking, I think the conventional wisdom is that there is a distinction between the role of arbitral institutions and the role of arbitral tribunals that are appointed under the rules of these institutions. And conventional wisdom, which is reflected extensively in the literature, is that the role of institutions is to administer the disputes exclusively, and the role of arbitrators is to decide the disputes exclusively. It's something that's reflected, of course, in the ICC rules. It's reflected in the LCI rules. It's not reflected in the ICDR rules directly, although there is this notion of ICDR potentially having the power to administratively dismiss claims in certain circumstances. And so you've got this notion of administrative role of the institution. And certainly when I was working for an arbitral institution, I always struggled with this conventional assumption, especially when that assumption is extended in the literature to say that arbitral institutions don't really have any impact on the decision-making process, if you want, of arbitration. That they're exclusively providing administrative services. And the reason why I struggled with it is because, first of all, arbitral institutions in reality, as per their arbitration rules, often make decisions within the context of the arbitrations they administer, whether it's a decision on setting the language of the arbitration, the seat of the arbitration, the number of arbitrators, appointing default arbitrators, removing arbitrators, whether it's deciding joinder or consolidation. And so they do make decisions. And so a lot of the literature continues with this conventional assumption and says, well, these decisions are administrative in nature. They're somehow functionally or organically different from the decisions that are made by arbitrators. And I understand why we have that distinction. I think the idea is that the process is already complicated enough, and cost and delay are already complicated, already big problems for the users. The last thing that we want is for institutions to have to provide reasoned decisions for every single decision they make, or for parties to really have that right to be treated equally, or rather to have a full opportunity to present their case for every single administrative decision made by an institution. Or worse, parties being able to challenge arbitration decisions throughout the process, disrupting potentially the arbitration. So I get why we want to qualify this role of institutions as being completely different from what the arbitrators do. But is that really always correct, or does that really reflect the reality of institutional arbitration? Again, I'm mindful there's different types of institutions, so I might explain differences. So what's your views on that?
Why are you asking that too?
Anybody who's courageous enough to tell me what they genuinely think about the question.
Well, if that's a very complex question, but I would say that the distinction between administrative decisions and jurisdictional decisions, it's not conventional wisdom. I think it's good legal thinking, and it's very important to maintain because it's the basis of what institutions do. Now, it is true It is true that conceivably an institution may take decisions which are jurisdictional in nature, as much as an arbitral tribunal may take decisions which are not jurisdictional, which are administrative. Okay? If a tribunal, for example, in a non-institutional context fixes fees, this is not jurisdiction. This is an administrative decision in nature. If a tribunal fixes the venue of a hearing, this is not a jurisdictional decision. What controls the distinction is whether the body would resolve a dispute in a final way by applying a legal rule. At least that would be the French doctrine. And that, I think, is what controls the distinction. It's not always, of course, clear-cut. I've always thought, for example, that when institutions decide on challenges, they do that based on extensive written submissions by parties and also comments on the arbitrators by applying rules that are legal in nature. I think that the argument could be made that these decisions are not purely administrative. They also have a jurisdictional dimension. Okay, many other decisions that are made by institutions. You mentioned the seat of the arbitration. I think that falls into the realm of administrative decision. For example, the scrutiny of awards in the ICC context is a pure example of an administrative process because the court does not decide anything. It raises the attention of the tribunal on questions of substance. It may impose changes to question of form, but it does not resolve a legal dispute by making these comments to the tribunal. And maintaining that distinction and the clarity of that distinction is essential to the life and proper functioning of institutions for a number of reasons that you have outlined.
Thanks, Alexis. I'll certainly come back to you on certain things here, but I see Ismail, did you want to say something?
I will speak also about my region because sometimes there are some parties, especially governmental entities, when they are not defended by a sophisticated lawyer with an international exposure, sometimes there is a misunderstanding and the confusion between the role of an institution, for example, when it decides upon to register a case or not, or to proceed with a case based on a prima facie test, and the decision of the arbitral tribunal on its jurisdiction. So usually an institution, when it will make its decision, the prima facie test, and will decide to proceed, it won't provide reasons for its decision. But we endeavor to provide some reasons to face this lack of understanding and confusion between the role of the institution. This is an example, the prima facie test, and the jurisdiction or the power of the arbitral tribunal to decide on its own jurisdiction. So
But here, Ismail, you're talking about prima facie, the distinction between a prima facie decision on jurisdiction by an arbitral institution, which is, first of all, prima facie, so it's not a deep analysis. It's a question really of a manifest, absence of agreement to arbitrate, really, for most institutions, and the actual decision of the arbitrators on jurisdiction. And that's a fair point, except that in some institutions, and again, institutions are not a monolithic concept, right? In institutions in mainland China, if I'm not mistaken, institutions like CTAC, for example, have got the power to make final decisions on jurisdiction. In fact, the default under the rules is that it's for the institution to decide jurisdiction, which it can delegate and often does, as I understand it, to the tribunal, or otherwise the courts can also decide jurisdiction. But it's not that the default is that the institution itself decides jurisdiction, not on a prima facie basis, on a final basis. So here again, we've got a different type of decision that seems to me to really escape that notion of administrative role of institution.
Of course.
Yes.
Yeah, sorry. Go ahead.
No, I was just going to say, I think that there is certainly a difference when we're talking about these Chinese institutions, as you've indicated. But I do think that generally speaking, the roles of administration between, or the responsibilities between institutions and tribunals fall along the line of before the constitution of the tribunal and after the constitution of the tribunal. The functioning of the arbitral institution is fundamentally to move the arbitration process along, to help to facilitate dispute resolution to the extent that the parties have prima facie agreed to enter into the forum of arbitration, right? So if the parties have prima facie entered into the realm of arbitration, institutions are beholden to exercise the will of the parties and get the tribunal constituted. And part of the role of the institution is also create enough parameters and guidance within their rules to facilitate that process. And some of the roles have been well delineated in recent rule revisions to expressly indicate the inherent powers of arbitrators and tribunals that haven't been expressly indicated in the past. So I do think that there is a fairly clear role pre and post constitution of the tribunal that I think that one can refer to when thinking about the delineation of responsibilities between the institution and the tribunal.
So I think that there's no question that generally speaking, we understand what's the role of the institution, what's the role of the tribunal, right? The institution is not there to decide the merits of the dispute. It's very clear. But if we dig a bit deeper, it doesn't necessarily, I think, mean that the institution's role is purely administrative. Let me give you another example.
Henny, sorry to interrupt. I'd like just to come back on what this man said because it's very interesting. The CETA that you mentioned clearly, well, it's an outlier, but clearly that's jurisdiction. But the prima facie assessment of jurisdiction by institution is a very interesting question because it can be positive or negative. If it is positive, it's clearly it's for the tribunal to make the decision on jurisdiction. If it is negative, it's the end of the story. But, and that's what the ICC will say, the matter goes to court. And then the court can contradict the institution and say, no, this is an ICC arbitration and you have to take the case, right? So there could be an argument that negative prima facie decisions on jurisdiction have a jurisdictional dimension in a way. But then you have a recourse which is going to court.
Which you also have, you have the same recourse when an arbitrator makes a decision on an award on jurisdiction. So that's, some might argue it's not a big difference. But let me give you another example of leaving aside the world of, former Soviet Union, arbitral institutions or Chinese institutions that trace their historical roots back to the old foreign chamber of trades, which were part of the judicial apparatus of the state. Leaving aside that, in Western institutions, you do have provisions sometimes that are interesting, like under the ICDR rules at the AAA. So it's for in some instances, the institution itself will decide which set of rules is going to apply, right? Whether it's going to be the AAA commercial arbitration rules or whether it's going to be the ICDR rules when it's not clear. And that decision has an impact on, for example, the remedies available to the parties. So a choice of ICDR rules is going to exclude punitive damages. So that is a decision which to me seems a little bit more than administrative. Or SIAC under its, the SIAC in Singapore has got the power to do this cost taxation, which I'm not very familiar with, but I seem to understand that it's a power to, if the parties to request the institution to pass decisions on costs beyond the legal costs, not arbitration costs. So all of this to say that it seems to me it's a bit more nuanced than we would like it to be, this topic. But the